today. So, today we're going to be continuing our reading of John Stanton's Breaking the Sound Barriers, and that's all about um, technology and tools that helped deaf lawyers succeed after the American with Disabilities Act was passed. Um, and so today what we're going to do is just kind of talk for two shakes of a lamb's tail about what is it that John Stanton does today and what are my thoughts on that in the construct of our society. And then we are going to keep doing our reading of the of his publication regarding breaking the sound barriers for deaf access in the law. At the end of my last live stream, I did do a fuller recap of what was read so far, but just to kind of give you a summary, what we discussed was key players in the pre-modern era before the ADA, and we left off uh, right. We stopped right before we got to the 1973 Rehab Act, which is where we're gonna pick off today. And so we also discussed like accommodation tools that have helped deaf people get access in the legal field, and we've discussed obstacles preventing deaf people from having access as well. And so that's what, in a nutshell, the part one was about. And so today we will be continuing off from there, um, and we'll be picking up at the time frame of the 1973 Rehab Act. And I have some more links about that concept also in the description of this video, particularly as it relates to Brad Lomax. And he was a member of the Black Panthers who is basically the reason, in my opinion, that, or I mean, maybe not the reason, but I feel like we could give him a lot of credit for why um, the 1973 Rehab Act and the 504 protests were successful for making sure that was carried out. You know what I'm saying? And executed. So, yeah. So I'm going to roll my fucking intro and then we'll get this bitch started. Hi, my name is Lexi, aka Deaf Child. I'm born deaf, hard of hearing. My team was one of the top teams between 2020 and 2024 in New Orleans and Louisiana. I began doing business as Deaf Child in 2013, marketing 2011, and sales 2009. I've earned 50 plus certifications in marketing and sales, and I have my Bachelor of Science from Loyola University, New Orleans, with a music industry studies major and a business administration minor. Visit my site at noladeafchild.com. So, yeah, I don't know if you can hear my best friend laughing in the background, but it's like my favorite thing, living with someone that you love. Whenever you hear them laugh, like if I'm having like a bad day or something and I just hear him laughing from the other room, I'll just instantly start feeling better. Um, but yeah, fucking. So I wanted to first just kind of check out John Stanton's LinkedIn profile. Um, and his about bio, it says John Stanton is an appellate attorney at the U.S. Department of Justice, Office of Immigration Litigation. Previously, he was a member of the appellate team at Holland and Knight LLP in Washington, D.C. Immediately prior to joining Holland and Knight, Mr. Stanton was a member of the appellate group of a large international law firm. I don't feel like I'm saying that word right. My bad. He has extensive experience in oral and written advocacy in federal and state courts nationwide at all levels. He has advocated for clients in a wide variety of subject matters, including commercial litigation, insurance coverage, white-collar criminal defense, securities fraud defense, government contracts, antitrust, environmental, intellectual property, trademark class actions, false advertising, Product Liability, Civil Rights, Petroleum Marketing Practices Act, and constitutional law issues. And I also noticed 9 months ago from his activity, it says, I've always been primarily speaking lip reading. While there was a point where I was reasonably decent in ASL, I've forgotten much of it. I'm sure it's like riding a bike, like, if he's, I feel like, but for me, I feel like this kind of speaks to potential evidence of lack of connection to deaf culture, in my opinion. And perhaps he's not so connected to deaf community in that regards, potentially. Um, so yeah. And so this is from his LinkedIn. And then when we look at the Judicial Nomination Commission, they also have a bio about him. This is linked in the description of the video. And it says, John F. Stanton, Esquire, is a trial attorney at the United States Department of Justice, Office of Immigration Litigation, Appellate Section, where he frequently appears in federal courts nationwide on behalf of the United States Attorney General. Before joining the Department of Justice in 2014, Mr. Stanton worked at Holland & Knight, LLP, and Howry, LLP. While in private practice, he litigated cases involving complex civil and criminal matters in state and federal courts, primarily at the appellate level. Is it appellate or appellate? Shit, man, I'm sorry. I feel like I'm not fucking saying that right. Further, he has written several articles in law journals and other legal publications on various topics. Deaf since early childhood, Mr. Stanton currently serves on the board of directors of the Alexander Graham Bell Association for the Deaf and Hard of Hearing, A.G. Bell. And by the way, a lot of people in deaf communities, such as myself, consider that an organization that promotes ableism, oralism, and autism against deaf people. So this is something to note here. A lot of people consider this an organization that perpetuates discrimination. So some people might consider John F. Stanton, someone who may be tokenizing himself as a deaf person in that role. Potentially. Okay. And so check my Alexander Graham Bell playlist for more about that. So anyway, it says he was a recipient of A.G. Bell's Honors of the Association Award, recognizing, among other things, his extensive pro bono legal work for A.G. Bell and the greater disability community. Mr. Stanton, what legal work for A.G. Bell? Like, you see, I don't like, why is, this is just disgusting to me. Anyway, the way that people have inserted A.G. Bell as this champion when he's a piece of shit, it just pisses me off. Anyway, it says Mr. Stanton also frequently serves on panels discussing disability access. In 2016, he moved for the admission of a group of deaf and hard of hearing attorneys to the Bar of Supreme Court of the United States, which generated extensive domestic and international press coverage. Mr. Stanton received a Bachelor of Arts degree in government from Dartmouth College and a Juris Doctor cum laude from the Georgetown University Law Center. Following law school, he served as a law clerk to the Honorable Nathaniel Jones on the United States Court of Appeals for 6th Circuit. Alrighty. Next up, just one more thing before we get back into our reading here. I put in the search engine result page for Office of Immigration Litigation, Appellate, shit, man, I'm sorry. Section does what? And so I'm gonna just call this OIL because Office of Immigration Litigation, and he's the appellate section, but I'm gonna just refer to this as OIL because I can't say that fucking word. So, in his role at OIL's primary responsibility is to represent the U.S. government in civil immigration cases before federal, courts. I can't say that. Appellate shit. So, that section handles cases that involves individuals who are subject to removal from the U.S. or who are eligible for benefits that would allow them to remain in the country. And so, yeah, he would be writing motions and briefs, arguing cases, coordinating with other agencies, and supporting the Office of the Solicitor General. So it's a separate component of the Department of Justice located in the Civil Division. and they hold primary responsibility for civil immigration case litigation before the federal courts. So, in my opinion, I think there is an argument to say or question, perhaps he may be part of upholding colonialism. You know what I'm saying? So there's a lot of fair critiques to have of John F. Stanton's career path, in my opinion. But I still do appreciate the advocacy and the barriers he has broken for deaf community. But sometimes I wonder at what cost. You know what I'm saying? Like, is it not great? Is it ungrateful to criticize, the means in which somebody took to create deaf access? Am I supposed to just be excited for the deaf access, right? I definitely think he's a key figure in deaf history that should be acknowledged and discussed about for deaf awareness. I don't know how I feel about the dude. I don't know the dude. I haven't researched him, that much beyond reading his words and looking a little bit into his career. So I don't know shit about him. I don't know about his cases. I don't know, but I just feel like, if people have questions and stuff, that's valid, right? In my opinion. So, and just putting that into consideration in context of where is the perspective we are reading coming from. You know what I'm saying? So, yeah, moving on, I would like to continue our reading of part two here. So I did try to give you a little summary in my introduction. And if you want to watch my last live stream part one, in there I give you a summary of what we've read so far. So from here, I'm just going to continue my reading, and we're going to be picking off at item number 2 here on page 28 of what is linked in the description of the video at this time. And we're going to be talking about the Rehabilitation Act of 1973, starting over, in regards to deaf access in the legal field. So, it says, encouraged by the legislative success of other minority groups, disability activists, as well as their family members, focused throughout the 1960s and early 1970s on seeking greater legal protections that would ensure their acceptance into greater society. A decade of lobbying finally paid off when President Nixon signed the Vocational Rehabilitation Act of 1973, quote unquote, Rehab Act. The primary effect of the Rehab Act was to appropriate 1.55, I can't speak, I don't know what the fuck is wrong with me, $1,055,000,000 in federal aid for disability services. But the most significant provision of the Rehab Act was Section 504, which read in relevant part, no otherwise qualified handicapped individual in the United States shall, solely by reason of her or his handicap, be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. That was I just popped my fucking ankle, dude. I don't know what the fuck I did there, my bad. Alright, A, law schools. In the immediate years after passage of the Rehab Act, there was an enthusiastic push among the deaf community to enroll deaf students into law school. According to Gannon, the now defunct National Center of the Law, National Center of Law and the Deaf, encouraged a number of deaf students to enter law school. By 1980, there were 20 deaf students in law schools around the country. This was quite an impressive jump, given that only one law school, the University of Wisconsin, ever formally adopted disability as a criterion for affirmative action in admissions through 1989. Of course, getting admitted to law school was one thing. Getting through law school was quite another. What Gannon does not mention is that few of those 20 or more deaf law students in 1980 actually graduated. Yeah, but I bet it was because they didn't have their support needs met, not that they couldn't actually fucking do it. You know what I'm saying? And then it says, common sense suggests that lack of accommodations was a major culprit. Yep. Up until the enactment of the ADA, accommodation after admission to law school was still very much ad hoc. While it is true that some extraordinary deaf individuals made it through law school with minimal accommodations, yeah, some of us raw dog it. And I don't really think that makes us extraordinary. In fact, it makes us have mental breakdowns. And then it says, the task was extremely difficult. Many deaf students became discouraged and withdrew from law school out of frustration of not being able to understand what was said in class. I just became known as a problem child. And then it said, a large part of the problem was the text of the Rehab Act. Although prohibiting discrimination against people with disabilities, the Rehab Act did not contain a mandate that the recipient of federal funding make reasonable accommodations for the student or employee with a disability. As such, few schools and businesses interpreted these laws to mean they needed to hire costly interpreters for deaf students, or as if they're not already making enough money, or employees. Rather, schools interpreted the Rehab Act as only meaning that they could not refuse admission to an applicant because of a disability. Once admitted, the deaf student was on his or her own. Some post Rehab Act, pre ADA deaf law students paid for interpreters in law school out of their own pocket. Alright, so we see the classism at play here. A situation that would be unthinkable today. Others may do with minimal accommodations, such as sitting in the front row while attempting to read the professor's lips or borrowing friends' class notes. Yeah, that typically doesn't go well. It says at least one used family members as interpreters during extracurricular activities. In 1977, the Federal Department of Health, Education, and Welfare, the predecessor to today's Department of Health and Human Services, finally issued implementing regulations declaring that federal funding recipients should make modifications to educational programs and provide deaf students with auxiliary aids such as interpreters when necessary. This was a very positive step in the right direction. As one deaf lawyer put it, to me and all the deaf folks in town, it was obvious that providing an interpreter for classes was the minimum obligation the school had under the reasonable accommodation requirement of the law. Unfortunately, the regulations were either ambiguous or, in some instances, conflicting as to whether the educational institution or the state vocational rehabilitation department was responsible for providing for interpreting needs of deaf students. And so, if you, in my head, when you just think of like income disparity already between deaf and hearing world, you apply intersectionality on that, and that, you know what I'm saying? And you can see where the representation in deaf issues, some of that disparity stems from historically, in my opinion. So, yeah. Then it says the result was extensive finger pointing between schools and state vocational rehabilitation departments that ended up in litigation. This confusion undoubtedly delayed interpreting for deaf law students even further after the regulations were issued. For example, some law students paid for interpreting out of their own pockets and sued their state vocational rehabilitation department for reimbursement. Others sued their law schools for the failure to provide accommodations and then had to sue again when the accommodations that were provided were inadequate. At a minimum, these situations had to have been a huge distraction for the deaf students. So, linked in the description of my video, where I talk about Brad Lomax and the 504 protest regarding the 1973 Rehab Act, the protest was happened after the act was passed because of what they're explaining now in order to push society to actually follow through and provide accommodations. You know what I'm saying? But even after that, there is still all of these issues to where they were using these loopholes in the wording to not provide access. And the same thing happened again even after the ADA was passed. That's why there had to be an amendment between the 1990 ADA and the 2008. You know what I'm saying? So, yeah. All right, let's keep going. And all of that information linked in the description of this video. If you go through the playlist and through the resources, you'll get there. Okie dokie. So it says, admittedly, some situations worked out well for the deaf law student as far as funding was concerned. Some law students were able to obtain state vocational rehabilitation funding to pay for interpreters, or had the law school assume the costs. I was able to get state vocational rehabilitation funding to pay for my hearing aids. So, I mean, I do think that could be possible. See how that could be a thing. And then it said one law student was able to secure state rehabilitation funding to hire note takers for classes. Another secured a federal grant to pay for note takers in class her first 2 years of law school, but lost the grant for her 3L year after the Reagan administration took office and engaged in extensive budget cuts. Others found themselves in situations in which the state rehabilitation department and the law school shared the costs for interpreting and other accommodations. Such disparate situations may have created other inequities. Certain law schools gained a reputation for being good about providing accommodations among deaf students. Eventually, those law schools became the choice of several qualified deaf applicants, and the schools found themselves having to provide interpreters for several students at once. Although impossible to prove, one cannot help but wonder whether some admissions committees have turned away qualified deaf applicants because they were leery of having to provide yet another deaf student with expensive accommodations. That definitely happens. It says the ADA effectively alleviated such overburdening issues by making clear that every law school had an obligation to provide interpreting. I mean, on technicality of the wording, yes, but enforcing that is another fucking thing. Anyway, it says, hence, deaf students today no longer need to flock to a certain school because of its reputation for being good on accommodations, when they know full well that they can get appropriate accommodations at virtually any other decently funded law school. I would say on some levels it's true that there's more options and opportunities for the deaf to get accommodations, but on another level, that's not necessarily true because uh, you're still gonna potentially get the same type of obstacles no matter where you go. You know what I'm saying? And then it says B, workforce. Whatever rights, if any, the Rehab Act granted to deaf students attending law schools, they did not extend to the private sector and employment. Private law firms, of course, did not accept federal funding and were not bound by any requirements of the Rehab Act. If the newly minted deaf lawyer did not graduate from law school summa cum laude and serve as an editor to the school's law journal, such as Professor Tucker or Susan Harris, or from a top 5 law school, such as Michael Tecklenburg, then applying to law firms was an exercise in futility during the Rehab Act era. I can see that. It says Bob Mather remembers applying for law firms after graduating from DePaul Law in 1977. An interpreter was needed to facilitate communication, and in the private firms, no one was even ready to talk about that. Yeah, me getting accommodations at this one fucking law firm, dude, they are a fucking joke in my opinion because they want to act like they give a shit about integrity, but do you really, if you don't care about deaf access or access for people with disabilities and mental health needs, you know what I'm saying? So suck my fucking dick. Anyway, it says Dean Voorhees' observation on employment prospects for the greater disability lawyer community was fully applicable to deaf lawyers. In the decade of the 70s, the bars to law school admission were knocked down. Job placement, however, has been entirely another matter. Sympathetic federal and state governments stretched out helping hands wherever possible, but the private sector has made considerably less efforts to provide employment. It has become increasingly evident that jobs with law firms in the private sector will be attained only with great difficulty and for few students at best. He theorized the reasons behind the resistance of firms to hire more lawyers with disabilities. Some law firms are convinced that the handicapped will prove incompatible with the other lawyers who have entered their employ. The partners may believe that to hire them will constitute a retreat from their established policy of hiring only the best qualified graduates they can find. So they admit that they are ableist, in my opinion. And then it says, they may be apprehensive that clients will react unfavorably to the appearance of a handicapped associate in an office in which they are accustomed to meeting young lawyers who are sharp, physically fit, and constantly on their toes. That's ableism, as if deaf people aren't. I am deaf, and I run a lot of, you know what I'm saying? I run about 5 miles a week sometimes. I'm in better shape than a lot of hearing people I know. So what the fuck is this bitch shit fucking saying? Fuck you. I don't know. Sorry, I started like gulping my coffee and then I kind of drank too much. All right. And then it says, indeed, law firms did not bother denying their reluctance to hire lawyers with disabilities. The hiring partner from Los Angeles office of Gibson, Dunn, and Crutcher went on record as saying, I'm not sure what the response of our firm would be in hiring a blind lawyer, but we'd certainly have to look at the cost. To compensate for lost efficiency, we would probably adjust the blind lawyer's compensation. What the fuck? Assuming that we're not as efficient or productive is just fucking discrimination, in my opinion. Just because we have different ways of doing things. You know what I'm saying? And then it says the hiring partner for New York's Kravitz, Swain, and Moore said that they would not want to put an applicant with a disability into situations they can't handle. And one Philadelphia firm turned down a Harvard law grad with the callous explanation that it didn't want to be confused with a freak show. The student was, I'm going to use, it says the student was a dwarf. I think that the correct term now might be, I don't know the correct term actually. Is it little person? I don't, but I know that we should be saying dwarf. I know that's not it, but that's what the quote said. Okay. Um, All right, and then it said, to the extent that deaf lawyers did find positions in law firms, they proceeded with minimal accommodations. Professor Tucker remembers that when she interviewed for a job at a large Denver firm, she just requested her own secretary, whom she would train to be an oral interpreter for phone calls and large meetings. Hey, Michael Tecklenburg likewise used very few accommodations at his law firm. Like any demographic, their experiences were mixed at firms. Professor Tucker achieved partnership at her firm before leaving for a successful career in academia. Miss Harris remembers that some people at her firm were very helpful and accommodating, but others were not. Yeah, that's true. In my experience for me. Okay. And then it says the other deaf lawyers who received their law degrees or became deaf during the Rehab Act era found employment in the government at public interest organizations or set up shop for themselves. A 1989 article dedicated to deaf lawyers said that there were only about 15 deaf lawyers in the country and profiled 11 of them. Of those 11, 8 worked for the federal or a state government. All lawyers interviewed expressed satisfaction with their careers, and one of them, Deborah Luther, today is an administrative law judge for the Interior Board of Indian Appeals. Is she native? I don't know how I feel about this if she isn't indigenous. Mm, that sounds colonial. All right, let's keep going. It says state and local bar associations did not make things easier for deaf lawyers. Neither had a good history of accommodating deaf lawyers, refusing requests to hire interpreters for lectures or workshops, or even requests for preferential seating in the front row so the deaf lawyer could try lip reading. To its credit, the American Bar Association appears to have been ahead of the curve, providing interpreters for deaf lawyers even before the ADA was enacted. C. Increased visibility. In addition to actual progress at law schools and employers, the Rehab Act era produced at least 2 instances of extensive media attention in cases in which a deaf lawyer was counsel of record. Lowell Myers representing Donald Lane, and Michael Chadoff representing Amy Rowley. Lang was either born deaf or became deaf as an infant. His family was too poor to provide for special education such as speech rehabilitation or sign language instruction. They forced me to do speech therapy in school, so. And then it said, and he grew up without any language other than some homemade signs between himself and his mother. Lang's mother passed away when he was a young adult, and Lang was left on his own. He obtained a job at a loading dock and gained a reputation as a hard worker and an affable fellow, even though he could not communicate with anyone other than through the most rudimentary signs. Some of his co-workers acquainted Lang with the practice of hiring hookers for sex. On November 12, 1965, prostitute Earlene Brown was found dead, and Lang was one of the last persons seen with her. Lang was indicted for Brown's murder. Damn. Myers was appointed as his attorney a few weeks later. Because Lang did not know any recognized form of sign language, he could not communicate with court officials nor Myers. As such, he was deemed incompetent to stand trial and held in a mental institution. I'm just going to reflect on this ableism at another time. I haven't processed this yet. And then it says, as the years passed, attempts to teach Lang formal sign language proved futile, and it appeared that he would never acquire the necessary communication skills to be deemed competent to stand trial. I'm sure there probably were ways to help the language deprivation or language disfluency, but that it hadn't been studied enough to help yet, and the colonialism was too much. I don't know, in my opinion. But then it said, Myers eventually filed a petition for a writ of habeas corpus, arguing that the state could not detain Lang indefinitely. He should either stand trial or be released. The trial appellate courts denied a writ, but the Supreme Court of Illinois agreed with Myers that Lang could not be kept in custody indefinitely without trial. Upon remand, Myers discovered that much of the physical evidence obtained by the police for Brown's murder 5 years earlier spoiled due to mishandling. Because the state had no proof to make a case against Lang, he was released. This tracks. Unfortunately, 5 months later, the same situation recurred. Hopefully he was charged, he was arrested, he was convicted this time. Okay, it says Lang was seen with prostitute Ernestine Williams in a hotel, and Williams was later found dead in the hotel room the next morning. Lang was again charged with murder. Myers defended him in trial, arguing that other men had committed the murder. Come on, Myers, really? However, the jury disagreed and convicted Lang. Yeah, I'm like, oh, this is too much of a coincidence. Like, is that really a setup? You would have to be able to prove it's a setup, and someone really was like, you know what I mean? Like, that would be a crazy coincidence setup, but it would really have to be proof for me to believe it. But no, that's true. Nah, I don't believe that. Anyway, after Myers ensured that Lang was sent to prison where he could receive sign language training, he withdrew from the case to concentrate on his regular work. While Lang's conviction was overturned on appeal because of his inability to communicate, he was again deemed incompetent for trial and has been in mental hospitals ever since. Damn, is he still alive? And then it says, Lang and Myers' story became the subject of a book in a 1979 made-for-television movie called Dummy. Well, that's ableist as shit. I mean, yeah, he's a fucking murderer. Why don't we just call him murdering piece of shit? No need to perpetuate ableism. Then it says, starring Paul Sorvino as Myers and LeVar Burton as Lang. LeVar Burton! You could never make me hate you, LeVar Burton! Yeah. Butterfly in the sky. Excuse me, hold on.
Take a look, it's in a book, a reading rainbow.
Sorry, I had to do that. And then I couldn't find the button to come back. Anyway, so then it said the movie was reasonably accurate in chronicling some of the challenges that Myers faced in practice, including using his sister as an oral interpreter for telephone calls and oral argument before the Illinois Supreme Court. Myers was allowed to leave the podium and approach the justices directly for lip reading. The other celebrated case in the Rehab Act era was Board of Education versus Rowley. A deaf 8-year-old girl named Amy Rowley wanted a sign language interpreter for her mainstream public school classroom, but the school district, not wanting to pay the cost of an interpreter, asserted that an interpreter was unnecessary because Amy was an above average student and passing her classes without any accommodations. That's what happened to me. And let me tell you, it was not necessary. It was necessary. You dicked me over and fuck you guys. Anyway, so continuing, it says Michael Chadoff was employed at the time by West Publishing and was a family friend of the Rowleys. He brought suit on the family's behalf under the Education of All Handicapped Children's Act, today the Individuals with Disabilities in Education Act. The trial court agreed that merely because Amy was progressing in class did not mean she did not need an interpreter. Yeah, boy! And the Second Circuit affirmed on appeal. Chadoff argued the case both at the trial and appellate levels, using a combination of lip reading and note taking. That's what I've been doing. Shit. The school board petition for what the fuck? I don't know how to say this word. Certiorari? Shit. Nope. To the U.S. Supreme Court, and the court granted the petition, knowing that it was one thing to try to lip read three judges on the. Is that fuck? Now I'm honest. How the fuck do you say this? Anyway, okay. Knowing that it was one thing to try to lip read three judges on the Court of Appeals, but quite another to lip read 9 justices on the Supreme Court, Chada filed a motion requesting leave to use a cart interpreter at his own expense. He should have had to pay for that. That's bullshit. According to internal court memoranda, there were attempts to encourage Chaff to let another attorney perform the oral argument. Ableism! Why not the court pay for the cart? Shit, dip fucks. Then it says, while debate over whether it is better to have the lawyer has been with the case from the beginning or an experienced Supreme Court practitioner deliver the oral argument at the court happens in every case, particularly when the case has far-reaching implications. Such efforts to get Chadoff to give up the argument were likely intensified by his deafness. Yeah, because you're ableist pieces of shit who didn't provide access. And then it said, Chadoff said that even if the court had denied the motion for leave to use CART, they should have been paying for the damn thing. He still would have tried to argue the case himself, find the best note taker he could, and pray for the best. Yeah, because deaf autonomy needs deaf representation, bitches. And then it said, the court granted Chadoff's motion. Boop. Although the cart system that Chadoff used was state of the art at the time, it was not sophisticated enough for the hectic back and forth pace that accompanies Supreme Court argument. Womp womp. Supporters who attended the oral argument say that the delay was about 4 seconds long between a justice's question and the time that Chadoff read it. That's not that bad. Y'all can suck a dick. Are you really that impatient? And then it said, but other deaf lawyers who used cart interpreting around that time said that the delay was significantly longer than that. Who knows? I wasn't there. And then it said, whether the delay was 4 or 7 seconds, the justices were uncharacteristically hesitant to challenge Chadoff at the Rowley argument. Only 2 justices, O'Connor and Stevens, asked Chadoff any questions at all. The American lawyer reported that the justices understandably seemed reluctant to interrupt Chadoff too often, as Miss Harris lamented when she read that account. One wonders how any advocate, much less a deaf advocate, can effectively present a case if a court, hampered by lower expectations and fear, does not want him to argue and is reluctant to challenge him. Yeah, because they are ableist pieces of shit. Alright. And then it says, making matters worse was when the lawyer from the U.S. Solicitor General's office got up for his argument supporting Rowley. Not only did the previously quiet justice immediately pepper him with questions, but also the lawyer was unprepared and was unable to supply answers about the factual record, issues that Chadoff surely knew by heart. The result was 6-3 decision, holding that Amy Rowley was not entitled to an interpreter under the law as long as she was passing her classes satisfactorily. That is such fucking bullshit. You know what I'm saying? And this is what perpetuates discrimination against deaf people. You know what I'm saying? And then it says, while the result was disappointing, the community took much heart that a deaf lawyer so prosecuted the case all the way to the Supreme Court. After the court granted Chadoff's request to use the CART interpreter, the case drew significant nationwide attention. In the book Great Deaf Americans, this just feels so colonial. I'm going to, in the conclusion, reflect on my thoughts regarding the law upholding colonialism. You know what I'm saying? All right. It says the authors devoted a chapter to Chadoff. They remarked, Chadoff's example of courage will not be forgotten. Even in losing, he made a giant stride for the deaf. Between the media coverage of the Lang and Rowley cases, the idea of a deaf person functioning as a lawyer, at least one who represented deaf clients, may still have been far-fetched to most of the country, but it was no longer unfathomable. Now we're going to go into fourth, after the ADA. And in my opinion, a lot of people like to champion the ADA because of the premise of its existence and the wording in it can sound nice. They like to champion it as this um, thing that has changed the world and now there's no discrimination against deaf. But there's so many loopholes in the ADA that it's really hard to actually get it upheld. You know what I'm saying? So that's just like another thing. But anyway, um, it says there are several ways in which the ADA was a significant improvement over the Rehab Act. For purposes of this article, the most important aspect is that the ADA explicitly covered employers, public accommodations, including schools, and public services, i.e. courts, and explicitly required covered entities to affirmatively provide reasonable accommodations to persons with disabilities. And I worked at a law firm that I don't believe did so for me. And so I'm going to try and tell my story on that when I can. But yeah, just putting it into perspective, even in the year of 2024, you still cannot get law offices. Law offices will not uphold the ADA in 2024. They will do everything they can to try and get out of it, in my opinion. Anyway, moving on, it says A, fortuitous timing for deaf lawyers. The enactment of the ADA could not have come any sooner for deaf lawyers. Indeed, in some ways, the timing was perfect. One of the great boons for deaf lawyers and law students was that the ADA took effect roughly about the same time that CART interpreting had improved to the point of being usable for deaf lawyers and law students. As discussed earlier, CART interpreting in the 1980s was limited by a significant lag time between the stenotyping of the words and the appearance of the words on the screen. This was the reason why CART interpreting was not embraced by deaf lawyers in the 1980s. As explained by Ms. Harris, time lag is every barrister's enemy. Critical objections cannot be made. Uncomfortable silence ensures. The law is it supposed to be ensues? The lawyer's competency is called into question regardless of preparation. The case is lost. I feel like that's just discrimination, and that speaks to this rush concept that is tied in with capitalism and colonialism. Like, if you feel like you need to get that argument out that quick and you can't just pause 1 second to make sure you process the right thing before speaking on it, and you would rather someone, pop them like a pimple before letting them properly give you a good argument, that's not, in my opinion, um, giving space for a fair and equal justice system. How can, you know what I mean? I hate that the justice system is built on that. This shows so many issues, not only regarding ableism, but regarding also the question of how people perceive oral arguments. You know what I'm saying? Um, I don't know. Like, and I watch a lot of court cases because I'm addicted to it. I'm addicted to watching LawTube. You know what I'm saying? So I'd like to watch court cases. There's silence in court cases all the time. So why is it only a problem if it's a deaf person? But it's totally fine if it's a hearing person. You know what I'm saying? So what the fuck is this? You know what I'm saying? Anyway, so, moving on, it says, however, by 1990, the programming advanced to the point where there was only a 1 to 2 second delay, more than sufficient for use in classrooms and courtrooms. The benefits of cart interpreting were immediately seized upon by deaf lawyers and law students. Richard Ricks, who had all but given up on his career as a trial lawyer when he became deaf 5 years earlier, resumed his criminal defense practice after the D.C. Superior Court implemented cart interpreting so Ricks could follow proceedings. Theodore Bertzos, later Judge Bertzos, who transferred, goddamn, from the Cook County State Attorney's Office Trial Department to its I can't say this word, appellate or appellate. I don't know how to fuck to say it, y'all. Appellate Division, after becoming deaf in the mid 1980s, did likewise around the same time. Lynn Weaver used cart interpreting in a clinic her 3L year at Harvard Law School to represent a client at an administrative hearing for an employment discrimination dispute. As part of a state exchange program between trial and appellate judges, Judge Brown presided over a trial using cart interpreting. According to Judge Brown, the extra second or two it took him to read the cart screen gave him time to formulate thoughtful responses to objections, and he was well received by the trial attorneys. That's what the fuck I was saying. Sometimes taking a minute just to think before you speak can be a good thing. The people wanting to speak without thinking, in my opinion, leads to why does that seem as better than thinking before you speak? What? This is why I don't get hearing people. Anyway, it says, and then when you tell a hearing person, look, if you don't give me time to process, you're just gonna get me thinking speaking without thinking, or you can let me think before I speak. They don't like what you have to say when you speak without thinking. Now then, all right then, you asked for my fucking honest opinion, bitch. Anyway, anyway, okay, so I'm still fucking salty over some shit. All right. So then it says, as far as publicity is concerned, there is no shortage of press attention focused on the deaf and disability communities in the aftermath of the ADA's passage. But deaf lawyers received even an additional boost when NBC aired a program in 1991 entitled Reasonable Doubts, featuring Oscar winner Marlee Matlin as a deaf prosecutor and perennial star Mark Harmon as her investigator and sign language interpreter. Although the show was critically acclaimed and won praise from deaf lawyers for presenting a very reasonable depiction of a deaf person functioning in a professional role, it lasted only 2 seasons. Still, unlike previous media depictions, Reasonable Doubts showed deaf lawyers using interpreters on the job and not limited to representing deaf clients. Professor Shorts recalls that the show was groundbreaking. It helped people to wake up to the idea of deaf people as professionals. That was a time and a day that I could point to and say on this day people's attitudes and perceptions began to change. And I just want to put in mind, I was born in 93. One of my deaf cousins was born in 91. So for me, I feel like this right here sets the historical context for the year I was born, for the ableism surrounding my family that we were born into. And you know what I'm saying? And so, yeah. Um, I think I finished reading. This was a time and day that I could point to and say on this day's people attitudes and perceptions began to change. I think I read that. Moving on. It says B, for deaf law students. Thanks to the success of deaf lawyers in the Rehab Act era and increased publicity, law schools largely dropped any previous biases or prejudices against admitting deaf students by the time the ADA was enacted. So long as the student had the necessary record, she was admitted to law school. Oh, I love how you put he's switching between the he and she here. Let's get some she's in there. Now where are the days and downs? Alright. And then it said, but getting the record necessary for admission to law school was still an issue for some aspiring deaf law students. Many students, for example, took a preparation course for the law school admissions test, LSAT, in hopes of increasing their chances of being admitted to law school. A company called Testmasters that provided preparation classes for the LSAT refused to provide interpreters for deaf students who wished to take the classes. In 2004, a deaf student complained to the Department of Justice about Testmasters' refusal to provide interpreting access to its classes. Shortly thereafter, Testmasters agreed to provide proper accommodations for deaf students. Once in law school, deaf students, especially the ones who did not know much sign language, eagerly embraced CART interpreting. It appears that Stanford Law was the first to provide CART interpreting to a deaf law student in 1991. Several other law schools followed suit in the following years, including Georgetown Law when I enrolled in 1993. Damn. Okay, so John Stanton was enrolling in law school when I was being the year I was being conceived and born. That's fucking hilarious to me. Um, and then it said, it is difficult to put into words just how much of an impact CART interpreting had for those that used it. Mr. Chen said of having CART interpreting at Stanford Law, for the first time, I am actually learning something from classes. I wonder at times, I can't speak, I wonder at times how much better my undergraduate classes would have been. Mr. Shit, can't say this right, Mr. Macchiolati, close enough, Macchiolati, expressed similar sentiments. He repeated his first year at Cooley Law School after concluded it was largely a waste of time sitting in class without any accommodations. See, that's how I felt in fucking high school and college, and requested CART interpreting the second time around. After his first semester with CART interpreting, he received a certificate of merit for the highest grade in his criminal law class. Even setting aside the direct benefits of being able to understand the classroom discussion, CART interpreting provided residual benefits for the deaf students as well. For example, deaf students often either never participated in classroom discussion or were never called upon by the professors, presumably from discomfort or misplaced pity. When I received CART interpreting, my own professors called upon me as often as any other student. Likewise, I also asked questions in class when I thought it was necessary. I would like to think that my classroom participation left a favorable impression upon my professors and classmates because I could think on my feet and make convincing points, both widely assumed to be requisites of a good lawyer. I don't think my teachers like me because I talk way too much and I fucking love to argue. Alright, and then it said, one drawback, at least from the perspective of the schools, to CART was that it was expensive. For law schools that had several deaf students, multiple requests for CART interpreting resulted in significant interpreting expenses. For example, the University of California, UC, school system, both for undergraduate and graduate schools, became a popular destination for deaf students because of a perceived progressive attitude for providing accommodations. At some point in the mid to late 1990s, both the universities of California at Berkeley and Davis, feeling that the costs of interpreting were getting too high, decided that they would not provide CART interpreting to deaf students and forced them to make do with less costly sign language interpreters, even though the deaf students requested CART interpreting, or otherwise hired even less costly, inexperienced, and or inadequate interpreters. This is ableism and discrimination against the deaf, in my opinion. Alright, and then it said, predictably, a group of deaf UC students, including Bolt students Janine Kramer Madeira and Emily Alexander, filed a class action lawsuit against the UC system alleging Rehab Act and ADA violations. Yeah! The case eventually settled, which both sides claimed was a victory. There are other examples of how the ADA forced law schools to get with the program regarding accommodations. One lawyer, he requested anonymity, recalls a fuck. I don't know how to fuck to say this word. Recalcitrant or recalcitrant? I don't fucking know. Is it recalcitrant? law professor who stubbornly refused to attach an FM microphone to her lapel for class lectures, saying that she had a personal aversion to microphones. What a piece of shit. When the administration proved unwilling to talk to the professor, she was married to a dean. The student complained to his state rehabilitation department officer, who in turn got involved. Rather than wearing the FM microphone on her lapel, the professor instead proposed attaching it to the lectern and promised to teach the class from the lectern. Yeah, like that happened. The next class, however, she reverted to her usual habit of walking around the classroom, rendering the FM microphone useless. Following another round of complaints, she finally agreed to attach the FM microphone to her lapel. The lawyer says, I firmly believe that this outcome would not have been possible without the ADA's requirements for reasonable accommodation. He also reports that he had no other issues with accommodations in other classes and that he received a first-rate legal education. And keep in mind, the ADA is a defense for deaf people. It doesn't mean that people automatically follow it. And so a lot of times, by the time we can take legal action and get you to go through with the thing, it's like sometimes it's too fucking late and we just didn't get fucking access. You know what I'm saying? And so, yeah, C. Preparing for employment. After law school comes the bar examination. Prior to the ADA, bar review courses did virtually nothing to make courses accessible to students with disabilities. Not having access to such bar review courses, some of which boasted passage rates as high as 90%, clearly put law school graduates with disabilities at a disadvantage from their hearing peers. Many deaf students did not bother signing up for bar review courses, reasoning that without accessibility, the lectures were next to worthless. Several failed their bar examinations. Some paid classmates to take the course if the classmates shared notes with the deaf student afterwards. Shit. I mean, you gotta do what you gotta do. In 1992, Suzanne Rosen Singleton, then fresh out of UCLA Law School, requested interpreters after she signed up for bar/breeze bar review classes. Bar/Bree offered transcripts of the lectures to Miss Singleton rather than interpreters. Miss Singleton countered that transcripts were not the same as a live lecture because, among other things, the lecturer's body language may indicate the significance of the material being discussed and filed suit against Bar/Bree's parent company. When another recent deaf law school graduate, Jennifer Olson, and a blind student made similar complaints against Bar/Bree, the U.S. Department of Justice filed suit in federal court alleging ADA violations. Bar/Bree and the government reached a settlement in which Bar/Bree agreed to provide interpreters for live lectures for deaf students and to pay restitution. And we should also keep in mind every deaf person has different access needs. So a lot of things hearing people do will be like, well, one deaf person needed this, so I'm going to only do that. And I'm like, no, bitch. Every person has their own needs. And if you're not accommodating each person, that's ableism, in my opinion. And so, yeah. And then it says, there was also the matter whether deaf students needed accommodations for the examination itself. Relatively minor accommodations, such as interpreters to relay the proctor's instructions or to alert the examinee's time warnings, have been provided. More controversial is whether the extra time should be allotted for deaf examinees, particularly for those native language is ASL, because the student usually thinks in ASL and translation into English takes extra time. I am sympathetic to such requests, but question whether the disability being accommodated is deafness, which is a legally recognized disability, or lack of English proficiency, which is not. Um, in my opinion, it's related to deafness because if you all deaf people, most deaf people are that know ASL are bilingual. If you can write in English, you're fluent in English. You're proficient in English, whether or not you're speaking it. So that's you continuing and perpetuating discrimination. Deaf people, just because we know ASL and ASL is our first language, doesn't mean we have lack of English proficiency if we can speak it, read it, and write it. Can't suck my fucking dick, bitch. Anyway, and then it says, then there is no applying for jobs. An ongoing debate for deaf lawyers is whether to disclose their disabilities in the job application process. I make it my goddamn email. And then it says, I have discussed the issue with many deaf lawyers, and sentiment appears divided. Some, especially those who can speak and lip read well, prefer not to bring up accommodations until after they have a job offer in hand, fearing that only negative consequences can arise if they give a potential employer advance notice of their deafness. That does happen. Others, myself included, are upfront about the nature of the disability and list the accommodations that would be necessary for me to perform the job. That's how I am because, or how I try to be, because like I don't want to work somewhere I have to fight for access. You know what I'm saying? Some deaf law students have brought I'm back to that point. I will fight for access at places for the principle of the matter, but I still don't want to have to work somewhere I have to fight for access to be in. You know what I mean? And then it says, some deaf law students have brought interpreters to on campus law firm interviews. This created its own frustration. Recruiting attorneys, not being used to interpreters, would improperly direct their questions to the interpreter rather than the applicant. Right, that's fucked up. D. For deaf lawyers. After the ADA was enacted, employment prospects for deaf lawyers improved, although they were far from perfect. For one thing, with improved accommodations, they were not only able to get into better law schools, but also could perform better at those schools. In turn, this made it easier for employers to take a chance, if one were to use that term, on them. Law firms also seemed more receptive to providing for accommodations. For example, Brobeck hired a full-time interpreter for Miss Kurlander and had the interpreter perform legal assistant tasks during downtime. The Phoenix officer, why did I say officer? The Phoenix office of Meyer, Hendricks, Victor, Osborne, and is it Meldon? Agreed to share the cost of an interpreter who served as both Jamie McAllister's interpreter and a firm paralegal. Albert Lynn, a partner in the Austin office of Brown McCarroll, LLP, reports that his firm provided car interpreting for meetings and conference calls, as well as a CapTel caption telephone for him to perform his responsibilities. As Melissa Felder, an associate in the DC office of Boyd, Schiller, and Flexner, LLP, puts it, because litigation is all about communication with adversaries, clients, witnesses, and even the courts, people often ask, how do I know what needs to be done? The answer, in today's world of advanced technology, there are accommodations for nearly every situation, and if not, some on-the-spot improvising fills the gap. Thanks to these relatively unobtrusive accommodations, I am able to do everything I need to do as a litigation associate, talking to clients and actively participating in meetings, trials, and depositions. And I'll say for myself, particularly since 2020, when everything's been super mainstreamed for me with access working, and almost all of the meetings I do, a lot of them are online, and I can caption that shit. You know what I'm saying? So that's how I've been doing it. So yeah. And then this says, this is not to suggest by any means that all law firms set out the welcome mat for deaf lawyers after the ADA. While no law firm would be caught dead expressing some of the sentiments that were made prior to the ADA, discrimination in private firms did not end after the ADA was enacted. In fact, it's still happening today. For example, 3 years after her hiring, Miss McAllister's firm faced hard times and laid off many lawyers, including Miss McAllister. She was not able to secure employment at another firm. Ooh, I'm getting a notification here. Okie dokie. I don't think it's disconnected. Hmm. Whoops. I accidentally minimizing stuff. Anyway, um, where was I? It said she was not able to secure employment at another firm and notes with some bitterness. It would be impossible to prove discrimination, but when you compare the credentials of people other firms hired with my own credentials, there's a disparity. Miss McAllister ended up taking a position with the Maricopa Public Defender's Office and found the work very rewarding. As was the case during the Rehab Act era, many deaf lawyers found employment with the government. But governments were not immune from such biases after the ADA was enacted. Oh, you know what? Let's go back to this. It is really hard to prove discrimination, but I think that I may have gotten the attorneys, someone from the attorney's office that discriminated against me to basically admit it in writing, in my opinion, to me, that they discriminated against me based on disability, in my opinion. I think that I got that in writing, in my opinion. Anyway, so which is fucking hilarious. Like, are you really not that like wow? Like, really put that in writing? You really put that in writing? Yeah. Anyway, cannot wait until the day I can share that. But it says, as with the case during the Rehab Act era, many deaf lawyers found employment with the government. But governments were not immune from such biases after the ADA was enacted. Scott Harrison remembers that the Florida First Judicial Circuit Public Defender's Office was the only office to give him a job, recalling that he had interviewed with many other public defender offices prior to being hired here, and none were inclined to give me the opportunity that the First Judicial Circuit Office did. Sheila Conlon Mentowski applied for an attorney position for a federal agency in San Francisco, but was rejected because the agency did not want to pay the costs for an interpreter. Marcia Taylor remembers that she was rejected for a position at a state agency because they didn't feel I was making an effort to find a way to talk on the phone. Alice McGill says that after she was invited for a second interview with an interpreter provided at the California State Legislative Council's office, you know when you are singled out when the Legislative Council himself asks, how will you communicate? I was fuming. I knew no other applicants would be asked that question. Right, because there's so many fucking access ways that we have, you know what I'm saying? Um, as if we can't communicate. Just because you're not providing accommodation for us doesn't mean we can't communicate. That's fucking bullshit. Alright, and then it says, the ADA did create opportunities for deaf lawyers to use disability rights as substantive law for their professions. Substantive law for their professions. Several went into public interest, particularly disability rights, hoping to use their personal experiences and perspectives to be advocates on behalf of people with disabilities. Others, such as Michael Stein and Howard Rosenblum, either joined or established private firms specializing in disability rights. Indeed, several other deaf lawyers have set up their own firms, providing various legal services to their localities. Susan Harris spent many years being mentored by a tax and probate lawyer at a large firm before moving to a smaller firm and then establishing her own trust and estates firm. Scott Harrison left his public defender position to set up a private criminal defense practice. Leonard Hall spent 30 years as an assistant city attorney in Olathe, Kansas, handling a variety of criminal and civil matters before opening up his own shop. The ADA requirement that telephone companies implement relay systems for deaf callers also proved helpful for deaf lawyers. While many deaf lawyers still utilized interpreters for telephone calls, relay services allowed for small firm or solo deaf practitioners to make telephone calls. Relay services also allowed deaf lawyers to make calls when they were not in their offices. For example, Judge Brown uses relay services to communicate with his staff to rule upon motions requiring immediate action when he is outside of his chambers. But relay services work only if the recipient cooperates. Marcia Taylor recalls frustration when she attempted to make relay calls and the recipients hung up out of ignorance, believing the call was from a telemarketer or impatience. Yeah, that's another fucking thing. It's hard to get access. Michael Stein recalls flat out prejudice. I had a case where the opposing attorney refused to talk to me through relay and said, God help us all if we have attorneys who can't hear. What a fucking piece of shit. God help you if I find you because I am coming for you. Who the fuck are you? Someone named that bitch. Okay, I'm sorry. Um, Someone said, some deaf lawyers also found trouble receiving accommodations in courts. Access to the courts from the deaf community is discussed more extensively elsewhere in this special issue. For present purposes, it will suffice to say that its experience has varied from court to court in terms of providing accommodations. For example, when Scott Harrison left the Public Defender's Office to set up his own criminal defense practice in 2006, he was surprised when he was told that the Florida courts would not provide him with court interpreting, Of course, it happened in Florida, am I right? The state took the position that any accommodations were the responsibility of the lawyer's employer, in Mr. Harrison's case, himself. In my opinion, the court should have to provide that shit. When Mr. Harrison pointed out the obvious that as a solo practitioner he could not afford to sustain the cost of an interpreter at trials, court administrators refused to budge. Ableism! Mr. Harrison filed suit in federal court, alleging ADA violations against the Florida state courts. Yup, the parties eventually settled, and the state, while denying liability, agreed to provide court interpreting for deaf attorneys and to pay for Mr. Harrison's legal fees. Because you were wrong, dipshits. And then it said, Terry Mosier found herself in a similar situation when the Kentucky state courts refused to provide her with an interpreter when she made court appearances. Disappointingly, the state mounted a vigorous defense of the decision not to provide Mosier with an interpreter, including that Miss Mosier lacked standing, that her claims were barred by statute of limitations and sovereign immunity. What the fuck? How the fuck do you lack standing? If she's deaf, she needs an interpreter. That is standing. Saying that deaf people lack standing to need an interpreter is just you discriminating against deaf people. Suck my fucking dick. You should be the one fucking paying for our shit. That's fucking ableism. Anyway, it said the court rejected every defense proffered by the state, and the parties eventually settled with terms comparable to the Harrison settlement terms. Piece of shit. And then it said, with regard to whether deaf attorneys can ever form an effective organization, attempts have been made by deaf lawyers to organize bar associations. However, such efforts have not been fruitful. And I actually think that that he wrote this before the Deaf and Hard of Hearing Bar Association may have existed, in my opinion. I think. And then it says, in the late 1980s, Leonard Hall established the legal network for deaf and hard of hearing attorneys, which is formed to put deaf lawyers in touch with each other and to put deaf clients with deaf lawyers, as many as were serving deaf clients. However, organizing proved difficult. Before the internet facilitated better communications, because assigning deaf lawyers would always prefer to meet at National Association for the Deaf conventions, whereas the oral deaf lawyers would always prefer to meet at the Self-Help for the Hard of Hearing, today the Hearing Loss Association of America, or the Alexander Graham Bell Association for the Deaf and Hard of Hearing conventions. And this shows the division between deaf cultural values and hearing assimilation here. Attorneys that are still trying to assimilate into the hearing world instead of fighting for deaf cultural advocacy, in my opinion, are going to lean towards things that align with Alexander Graham Bell and referring and framing deafness as hearing loss. But in my opinion, people who have a strong deaf culture and sense of deaf community and advocacy lean more towards deaf gain, deaf culture, and sign language values, in my opinion. Um, so the reason that there is the division is because people who perpetuate the idea of hearing loss and supporting AGB rhetoric are perpetuating cultural eradication of deaf culture. And so, you know what I'm saying? That's why there is the division, because it's tokenization of deaf identity to use your deaf identity to discriminate against other deaf people. Um, and so that's what the division is, by the way, in this situation. You know what I'm saying? Just so you know. Okay, and then it says, unfortunately, lack of consensus and logistics proved too difficult to get much meaningful accomplished, and legal network eventually dissipated when Mr. Hall, tired of carrying the organization upon his own shoulders, and few other deaf lawyers wanted to share in the work. In my opinion, this is leaving out a lot of context there that I was roughly trying to sum up, and that's very roughly. In the 2000s, deaf lawyers formed internet chat groups. These groups led to easier discussions between signing deaf lawyers and oral deaf lawyers nationwide. Attempts were made to form a deaf bar association. However, the efforts failed because of lack of a clear mission for the association and because of infighting among the group's principals. On the other hand, deaf lawyers have made inroads in joining bar associations that focused on the greater disability community. Many deaf lawyers have been involved in the ABA's Commission on Mental and Physical Disability Law and have been active in letting the ABA know about the deaf community's legal needs as well as the needs of deaf lawyers. In 2009, the Committee on Disability Power and Pride, CDPNP, was formed to serve this disability community by promoting, planning, coordinating, and publicizing events, projects, resources, and initiatives that strengthen the political power and showcase the pride of people with disabilities. The CDPNP is currently chaired by former Congressman and co-author of the ADA. He's a co-author of the ADA? God damn. Tony Coho. He's okay. Among other things, it seeks to promote lawyers with disabilities in the federal political appointment process. It has already been involved in the appointment of a few deaf lawyers to federal positions, and hopefully will continue to do so in the future. So yeah, and so at this point, I'm pretty sure that this was written before the Deaf and Hard of Hearing Bar Association um, was able to more cohesively form, but now it is in existence and it is a thing. And this was written 2011 to put that into context. So yeah, and 5 years later, he swore lawyers and members of the Deaf and Hard of Bar Association into the Supreme Court. So he was part of that as well. All right, so 5. Looking to the future. It is true that lawyers are currently facing one of the worst hiring markets in the legal sector. But I bet it's even worse now post COVID. Okay, so it says before the economy crashed in 2007, Judge Tato, I don't know, offered the optimist perspective of law firms hiring lawyers with disabilities. Law firms, I think, are increasingly sensitive to this aspect of hiring lawyers with disabilities. The real reason, it seems to me, for firms to be interested in hiring students with disabilities has nothing to do with either their legal obligations or charity or anything else. Law firms have no trouble finding really good, smart young people to be lawyers. But in legal practice, you need other kinds of people also. You need people who are tough. You need people who know how to deal with difficult situations. You need people who have good judgments, and there is no better pool of people, I think, for law firms to find than students with disabilities who have gone through law school that way. I feel like that's really fucked up. They're basically saying, yeah, people with disabilities should be lawyers because they deal with the shit we put them through. What? Fuck that. What the fuck argument is this? Anyway, then from but John F. Stanton continues by saying, I fully agree with Judge either Tato, I don't know, Judge Tato's statement that many lawyers with disabilities possess a certain resilience that provides an advantage over their peers. I mean, I guess that's a good point. I do note, however, Dean Voorhees made essentially the same pitch to law firms and anyone else who would listen throughout the 1970s and 1980s without much success. But I do predict that when the economy improves and law firms begin hiring again, more and more deaf lawyers will join law firms. Even if deaf lawyers choose to work elsewhere for whatever reason, the law firm option should be open to them. Just setting aside the ADA for a moment, much technology is being incorporated into mainstream law practice that removes the obstacles historically preventing deaf lawyers from succeeding in the profession. Email, for example, has displaced much communication that in years past would have been conducted over the telephone, and it is only a matter of time before televideo technology becomes standard equipment for the profession. So this was written in 2011, and that is now the case. Yep, he was on it. And then it says applications such as Skype and iChat represent the infancy of this technology, but soon people will be corresponding via face-to-face over their computers or PDAs. What the fuck does PDA stand for? I don't know. And then it's a personal device. I know that makes no sense. I'm making shit up. Okay. And then it said deaf lawyers should be able to benefit from this technology by lip reading the caller through high definition screens and we get captions. Should voice to text technology continue to improve and captions appear automatically on video screens for such calls, then deaf lawyers will truly have gotten beyond telephonic barriers. Hey! There are other examples of technology becoming standard practice in the legal field, in the legal profession that remove previous barriers to deaf lawyers. Ms. Felder observes that cart interpreting is always utilized at her depositions, I can't speak, at her depositions and trial, even at the request of hearing attorneys. Hearing attorneys find captioning useful to refer to the real-time transcript to evaluate how a witness has answered a question or to review which questions they have already asked. That's funny. So when the hearing people want it, it's no problem. It's only a problem when the deaf people want it, that need it. Okay, fuck you guys. Anyway, thus the accommodation that I require in these instances, it as captioning, is usually already provided as a matter of course. Oh my fucking god. For this reason, I also predict that access to courtroom lawsuits, like Mr. Harrison's and Miss Mosier's, will become increasingly rare. In addition to the precedents established that, I mean, I feel like, is the situation rare? I don't think so. Is the lawsuit making it to court rare? Yes. Anyway, in addition to the precedents established by Mr. Harrison and Miss Mosier, many courts are actually incorporating accommodations for lawyers with disabilities into the courtroom's design. For example, Madeline Cohen, a deaf lawyer with the Federal Public Defender's Office in Denver, remarks that her practice became much easier when the U.S. District Courts for the District of Colorado's new courthouse was built in 2002 and incorporated much of the latest technology. The new federal courthouse incorporated real-time screens, in CART, and infrared audio, mainly for translators, but also for audio amplification needs, into all courtrooms. It was and is fantastic. I use the infrared and do not need to make any advance or special requests. I just walk into the courtroom, grab a headset, and I'm good to go. The judges have been great about remembering to speak directly into the microphones and will often remind my opponents to do so without any prompting from me. I only appear in district courts a few times a year now, but it's a great courthouse and very disability friendly. Okay, that's wonderful to see that experience come about, considering how it looked 100 years prior. You know what I'm saying? So yeah, I like that. And then it says, I have seen, although not practiced in, several other courthouses that were either built or extensively renovated in the past decade, and they appear to incorporate the same technology as described above by Ms. Cohen. Such trends will continue to benefit deaf lawyers. But some problems are of human nature that no law can fix. Many deaf people have difficulty modulating the sound of their voices. Secret or off-record conferences with clients, co-counsel, or the bench during trial that are not intended to be heard by others may pose an issue for deaf lawyers. Yeah, that is true, because I talk real loud and I can't hear how loud I talk. So thoughts and prayers, my dude. Um, when people tell me to be quiet or to try and be quiet, they let me know I'm being too loud. Because of speech therapy, I'm then like, oh, okay, so I can try doing X, Y, and Z with myself to be lower, but I'm still not entirely sure how loud I am without you confirming it for me. You know what I'm saying? Um, so yeah. And then it says, this is usually done through whispering, and it is sometimes difficult for deaf persons to gauge the appropriate volume level their voices must be to be heard only by the listeners. Ba-doop. Another deaf lawyer who did not want to be identified said she has been chastised by judges in courts for shouting when he had no way. Oh, I said she when it was a he. Had been chastised by judges in courts for shouting when he had no way to realize just how loud he was speaking. I think those judges are ignorant as shit. They're either really fucking ignorant, no malice intended, they're just that ignorant, and it can still be the impact is ableism because of their ignorance. It's ableism, or they're maliciously being ableist and acting like they're ignorant, in my opinion. You know what I'm saying? And then someone else said, of course, just because we have the technology and the legal protections to succeed does not mean that success is a certainty. As Mr. Lin points out, as long as reasonable accommodations are provided, nothing in the ADA prevents employers from firing deaf lawyers for poor work quality, for failure to timely deliver product, for rudeness, for unpleasantness, and frankly, if they don't like the lawyer personally. In other words, Like any demographic of lawyers, deaf lawyers need to produce to succeed. So yeah, this is just a reminder. Just because the ADA exists and we're like asking for accommodations, not only does it not even guarantee us our accommodations, but also it doesn't mean we can't be fired for not working good and all. You know what I mean? So yeah, six, conclusion. And so we're gonna read the conclusion here, and then um, before I conclude the live stream, what I'm gonna do is sum up what we've chatted about so far today. I'm gonna sum up what we read today, then I'll sum up the whole publication itself, and then we will conclude the live stream. So, in so part six, conclusion. In 2008, a federal court ruled that the ADA does not require movie theaters to provide captioning access for deaf patrons. Fucking bullshit. It should, considering it's a public fucking space. Bullshit. I mean, I guess if you want to count, it's not all public movie theaters are public. They could be private businesses, but still, fuck y'all. So long as the theater simply let the deaf patrons into the theater like anyone else, there was no discrimination. That is discrimination. If you're not deaf, you can't decide what is or isn't discrimination against us. And you telling deaf people you're not discriminating against us when you are discriminating against us is discrimination. It's just gaslighting. And putting it in the law doesn't make it any less so. And then it said the plaintiffs appealed to the Ninth Circuit and sought is this I don't know how to say this. Amici curiae? Amici curiae? I don't know. Assistance from the deaf community. The community responded with several amici briefs urging the Ninth Circuit to reverse the district court and hold that the ADA does indeed require movie theaters to provide captioning access for their feature presentations. At least in part of that effort, the Ninth Circuit reversed the district court. No fewer than 5 deaf lawyers, myself included, were involved in the preparation of those amici briefs. These types of assistance would not have been available prior to the enactment of the ADA. The result was a major victory for the deaf community, and in all candor, for the rest of society as well. Deaf lawyers have come a long way, but there is still more to be accomplished. Those who have achieved success should be mindful of our history and appreciate that the road in which they have practiced did not always exist for deaf lawyers. And more importantly, they should take all steps to ensure that the paths for future deaf lawyers are even smoother than they were for us. I do love this part. He's saying just because we had it rough doesn't, he's saying, I don't want other people to have it to work as hard as we did. I like that. You know, I hate when people are like, oh, I had a shitty life, so you should have a shitty life too. No. You know what I mean? I really like that. All right, so let's just go real quick on a little recap of what we've read today. So today we covered the Rehabilitation Act of 1973 and how this was a point of starting over in the deaf community for gaining legal access and rights in society through the law, particularly in the legal profession. And it discussed how the 1973 Rehab Act impacted law schools, how the 1973 Act impacted I think it was employment for the deaf, see the workforce here as lawyers, um, how it impacted, let's see, increased visibility for deaf legal cases, um, as well as, I believe we did one more thing here. Um, Oh, no, that was it in regarding to 1973. And then from there, we went into what were the impacts of the American with Disability Act. Would, where did that fill in gaps legally that the 1973 Rehab Act had major loopholes, which the ADA still has major loopholes. So we looked over timing for deaf lawyers regarding technology and implementing access for our rights to be able to use a technology to accommodate ourselves. Um, we talked about how accommodations since the ADA have been applied for deaf law students. Um, and we talked about how deaf people are using the laws from the ADA after the 1973 Rehab Act to enforce their right to utilize technology to prepare themselves for employment and to take bar exams and to get access in the legal field, as well as discussing how for deaf lawyers, how the ADA helped deaf lawyers succeed in doing their job, but also what obstacles deaf lawyers had to face with being able to use the ADA to have human rights, you know what I'm saying, and access in the courtroom, particularly. And then after that, we wrapped up with looking to the future, with just thinking about where we think, he was thinking about 10 years ago, 15 years ago, where he thought deaf rights and deaf access were going to go with what's happening with technology. And much of what he was predicting came to be true. And so I really loved how he was able to see where things were going based on what had happened. Um, and so, yeah, and in conclusion, we discussed that deaf lawyers are still having to fight for our human rights, even though we've come a long way. But hopefully, the goal of educating on these issues is so that other deaf people have it easier down the road, right? And so that's what we discussed today with that reading. And so before I conclude the whole live stream, I just kind of want to roughly conclude, give you a conclusion on this entire document itself. And so, just to kind of recap, the Breaking the Sound Barriers, how the American with Disabilities Act and technology have enabled deaf lawyers to succeed as an article. In my opinion, the importance of reading and understanding this article is to better understand the history that deaf people have faced with why didn't we have legal protections, what did we have to do to get the legal protections we have gotten now, and what barriers are still preventing us from potentially having access in the future, as well as how can we use and take the lessons learned from these issues in order to create a better way of being for ourselves. Um, I feel like it's really important to, you know, educate yourself on the deaf legal issues, because when it comes to how, like today, even today, like when you look at Aixon versus Lawfer, and that is linked in that playlist linked in the description of this video. If you look at that case, for example, they were basically trying, the Supreme Court is trying to argue that people with disabilities don't need to test for accommodations, and we don't need to be able to sue businesses if they're not accommodating us. It's part of what they're trying to argue. I'm heavily summarizing. That's not the explicit wording. There's way more to it than that. It's about um, having testers test for us. You know what I'm saying? And the reason that that is important and the connection there is most disabled people can't afford to take legal action on our own regarding these human rights issues. So if we don't have these people whose job it is to do that for us, it's basically making it so we don't have a way to, or it makes it so we have less ways and it's way harder for us to ensure equal access. And it creates more disparity regarding that, because it's going to exacerbate the access that there is given for people who are luckier when it comes to income disparity, because those who suffer from income disparity aren't going to be able to get as much access as those who benefit from income disparity, even if they are deaf. Um, and so that's another thing to kind of keep in mind when it comes to all of that. And so this is all written from the perspective of a deaf person. This is an oralized deaf person who speaks and writes on his perspective of being a deaf attorney and fighting for deaf access as an oralized deaf person without. He doesn't seem to have a strong connection to deaf culture and deaf community, in my opinion, and he doesn't seem to have a strong connection to or he doesn't seem to have access in the society in which he's working. So in my opinion, I perceive him as possibly someone who is a workaholic, because work is the closest thing he gets to a system of access is, in my opinion, based on how I'm reading his words from his perspective and when I think about the articles that we put. So that's summarizing, bringing me to summarizing this live stream in conclusion. So today, what we checked out was just looking a bit more into John F. Stanton. Said John F. Stanton, and he is an attorney. He's deaf. He's an appellate attorney for the Office of Immigration Litigation at the U.S. Department of Justice. And he wrote this article that we read today called, well, we finished reading part 2 today, called Breaking the Sound Barriers, How the Americans with Disabilities Act and Technology Have Enabled Deaf Lawyers to Succeed. And real quick, for two shakes of a lamb's tail in our conclusion here, I just want to reflect for just a second about the concept of how the law upholds colonialism, because I also want to remember that the entire concept of this quote unquote United States judicial system is built off of taking away human rights. And so anytime we are fighting for human rights and for access under the US Department of Justice, but we're not, but without a tribal sovereignty, it's just exploitation of native land and suffering for our own benefit. So, in my opinion, I do perceive, a lot of problematic issues, and I feel hypocritical myself. Right, on one hand, I believe in accommodations, accessibility, and advocacy for deaf community, and the only way we know how to do it within the social constructs of the world we live in and are confined to are fighting within the judicial system available to us. Right, but on another level, in my head, the as long as we perpetuate and uphold this judicial system, we're just perpetuating and upholding colonialism. You know what I'm saying? So in my head, the focus should be tribal sovereignty and land back. Um, in terms of where deaf advocacy and focus needs to be for equitable human rights and intersectionality for me. But bring it back to where we are here, though, today, what we've been talking about from looking into John Stanton's role in immigration, that's where I initially see, like, okay, between the hearing cultural assimilation and the immigration concepts, I think there are some valid criticisms of could this be upholding colonialism um, when we're advocating for deaf advocacy, but not all deaf benefit, right? And so we can kind of see that when it comes to looking at how the deaf advocacy that exists, in my opinion, can also be perceived as also highly based on and perpetuations of income disparity historically, in my opinion, as well as other types of disparities. So, yeah, fucking. So that is going to kind of wrap up today's conversation. Um, I really just thank you so much for joining me today and for joining me this Deaf Awareness Month, for considering deaf advocacy. What does, fighting for deaf rights mean to us? And who are key players that have gotten us to where we are today for deaf autonomy, as well as how can we um, balance advocating for deaf autonomy um, while also advocating for other communities that are impacted by colonialism. You know what I'm saying? I hope that's what we're reflecting on today. So, yeah, thank you so much for joining me today. I hope you have a great night, or it's a daytime. I hope you have a great day. And yeah, see you next time. Thanks for watching. Join the loyalty program at noladeafchild.com/loyalty and check in during live streams to get points for rewards.